Yo, YouTube, what's poppin'? What's poppin'? I am back with another video, back with another reaction, right? K-Flock Federal Rico trial, snitch, testified, day one. I need K-Flock to be free. I just got done telling chat that if y'all not on the Twitch, come to the Twitch. You know what I'm saying? Noonie 3 times. Everything is in the description, right? But I need K-Flock to be free.
Day one of the K-Flock federal RICO trial has concluded. Opening statements and witness testimony started with an NYPD detective and a snitching inmate. Before we get into what happened on the trial, a few important documents that I must read for you guys. The government is seeking admission of 3 Instagram videos that contain clips of defendant's rap music. So we already know there's going to be lyrics and rap videos in this trial, but they're also trying to get Instagram posts, I guess. First, all of these video clips were posted publicly by the defendant to his own Instagram account, accompanied by captions. The fact that the defendant posted excerpts of his music to his Instagram account itself is evidence of racketeering enterprise charge in count 1. Government expects the evidence at trial will show that one of the ways the defendant and others of Testified DOA make money is by committing check and unemployment fraud schemes that require the defendant and his fellow gang members to continuously recruit people who would be willing to turn their personal information, debit cards, and other personal bank account information to the defendant and other Testified DOA members to commit fraud. The government's evidence, including from the defendant's Instagram account, will show that the primary way the defendant recruited co-conspirators for his fraud schemes was via Instagram. Popularity of the defendant's Instagram presence was crucial to defendant's success in these fraud schemes. Wait, are they hinting that he was using fans' personal information for these schemes? Evidence will further show the defendant posted excerpts of his music to his Instagram account, such as 3 videos that the government is seeking to admit here. 35-second selfie-style clip in which the defendant is depicted rapping along to music while what appears to be his own home. The defendant posted this clip to his Instagram account with the caption, "We don't f with no OYZ or jiggies. We could link up with our chops and get busy. Big EBK." Not friendly with OYZ gang, clearly. To shoot at OYZ. He got shot if he on River Park shit. Spin through the towers like I'm trying to spark shit. Oh no, that lyric's bad because he's pretty sure he's charged with the drive-by shooting at River Park Towers. So feds are clearly going to try to show that to the jury, connecting him with lyrics. Oh man. The next video is another selfie-style clip. Defendant is depicted rapping what appears to be his own home. Post clip to his Instagram. Every op shot biz to EBK DOA. The government evidence will show that every op shot in EBK DOA referred to the Testified DOA ethos of being EBK everybody killers, meaning they will shoot anyone. The song itself makes reference to the defendant's own membership in DOA. Defendant also used the song to establish his role. Defendant is promoting violence by rapping and engaging in real acts of violence, including shootings. He does not hide or shy away from violence. Another 42-second clip. Defendant is depicted rapping what appears to be his own home. The next clip. Top op, never hit and do what I do best and go live life. E4J Rip K, I really rap what I live. Ending with a quote from the music clip. The government's evidence will establish top op.
Is such a bot. He said E4J. Everything for J. Rip K. Everything for J Rip. Why the nigga so slow?
Prefers someone who has conflicts with everyone and never hidden. Means someone who is not afraid of confrontations. J. Ripke was a member of Testified DOA who was killed in 2021. Willingness to shoot friends of rival gang members. Every shot I threw hit his man. His disrespect for people who run from confrontation. Oh why, oh what? I made most of them ran. And here's a big part right here. The court should preclude evidence of Hernandez's firearm. So the victim did have a firearm on him. I actually had a comment say, why are you calling him a victim? What do you mean, brother? He got killed. That's literally what a victim is. I can't believe that was...
It's really new. It's really... See, that's where the court gets sticky at. You know what I'm saying? He got the best lawyer in the game. I think he got El Chapo lawyer. This is where it gets sticky at. This is where it get heavy at, right? Dramatic effect. It's like, he's not a victim because it's mutual. It's kind of like mutual combat in a sense, because if he is a part of another gang, it's like they know it's beef. So, boom. They seen each other. You know what I'm saying? It really all boils down to self-defense. You know what I'm saying? Because he had that motherfucker on him, and he walked up and he got boomed in design. He got boomed in the designer, right? That's his fault. He should never walked up. He should never been mugging my dog. He should never came out the wherever he was at, the barbershop. He should never came. He should have never came out. So that's his fault anyway. Mind your business, and you won't get. You know what I'm saying? You just thought you had you one. You thought you had you a free one. Nah, nigga. But nah, I don't know, bro. Like, I feel like they can't hit him with the M, bro.
It was a real comment, but let's keep going. Hernandez possessed a firearm at the time defendant shot and killed him. Defense is simply not proffered any admissible evidence that would render Hernandez's possession of a firearm relevant fact. I mean, it is relevant if they're going to go self-defense mode here, but once again, I don't think that's how New York works. As the government previously explained, under New York law, to have been justified in the use of deadly force, the defendant must have honestly believed it was necessary to defend himself from what he or she honestly believed to be use of imminent such force, and reasonable person in the defense position, knowing what what the defendant knew and being in the same circumstances would have believed that too. In other words, there is both subjective and objective inquiry into what deadly force was necessary. The jury may not rely on the knowledge learned after the fact, such as that Hernandez in fact had a gun, to determine whether the defendant's actions at the time were reasonable. The defense proffered they anticipate eliciting eyewitness testimony that Hernandez made verbal representations that he's going to shoot and that he's going to attack with a deadly weapon in the moment before he was killed, and that the fact that Hernandez in fact possessed a loaded firearm corroborates this eyewitness testimony. Wow, that's huge. The defense has eyewitness testimony that says the victim was going to shoot K-Flock. That's big, right?
Damn.
Even if defense was able to elicit such
Zach.
testimony, the government
Dramatic
disputes the probative value of the victim's possession of the firearm and how that would weigh against the unfair prejudice and potential confusion to thee. However, the defense witness statements, disclosures made clear that there is no such eyewitness testimony that Hernandez in fact was threatening to shoot or made any verbal representations whatsoever that he had a gun. If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys. Instead, the defense eyewitness will apparently testify that Hernandez was simply asking, "What the fuck are y'all looking at? Do you know where you're at?" before he was shot. The defense eyewitness will testify that she felt like Hernandez was going to try to shoot us because of Hernandez's body language and that he kept on repeating the same things over and over. Oh, this sounds like it's K-Flock's sister that was right next to him, right? Like, what are y'all looking at? You don't know where you are. And the fact that he reached in his pockets for something based on this proffer, the fact that Hernandez possessed a firearm, does not tend to corroborate any part of the eyewitness's account of what happened. The government intends to omit surveillance footage from multiple angles, much of which has already been submitted to the court. Indeed, the government disputes eyewitness characterization that Hernandez was doing in the minutes before his death could reasonably be construed as a threat. Whether Hernandez in fact had a gun is irrelevant to the jury's task, which is to put themselves in the defense's shoes at the time of the homicide, knowing what the defendant knew. On the other hand, there is extremely high risk that evidence of a gun falling from Hernandez's coat after his death would unfairly prejudice the jury's evaluation of what the defendant believed and whether he was reasonable to believe based solely on his knowledge of the time. Interesting. So what it sounds like New York's law is they have to pull the gun out and literally point it at you for you to be able to shoot them. It can't just be someone grabbing a gun in their coat.
What?
Kind of crazy. I mean, I don't know how I feel about any of that, dude. That's kind of ridiculous, right? I mean, that's basically like the dude's got to be fucking about to pull the trigger at me for me to be able to defend myself in New York. That's fucking scary because the defendant didn't know he had a gun yet because it was still in his coat, I'm guessing. What the fuck? Court should preclude portions of proffered testimony to defense witness Nicholas Zingus, defendant's A&R, manager at Capitol Records, to testify about the following topics: defendant's talent and potential as rap musician, defendant's calm nature, defendant's selfishness and ties to community, and his opinion that 99% of hip-hop artists grow up in violent environments and their music reflects the violence they saw, either firsthand or through third hand. We do not dispute the fact defendant's trait as a calm person may be admissible under Federal Rule of Evidence 44A. However, none of the remaining topics is permissible. So that was the last letter the government sent to the judge trying to get some things on their side there. All right, here's K-Flock's attorneys. Rap exhibits that lack proper authentication or which a factual nexus to this indictment has not been presently established by credible evidence should not be admitted at this time. The rap exhibits, the alleged lyrics contained and said transcriptions will be addressed. The government has failed to satisfy their burden under Federal Rule of Evidence 901A, which commands that to satisfy the requirement of authenticating or identifying an item in evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. The government is offering the rap lyrics accompanying videos and other documents reported to be captions written by defendant in connection with the public postings of the videos. However, there has been no proof offered that Mr. Perez controlled the relevant Instagram accounts or altered the posts that the government now seeks to admit.
I was thinking this. How do y'all how y'all can't prove that this man posted this stuff? Y'all know how much stuff artists, like upcoming artists, screenshot the picture of their phone and it be fake when they had the cash up to 2 bands or whatever the case may be. All that be fake. That be on somebody else's phone. If y'all don't notice that. So it's like, y'all ain't proved nothing yet.
A similar route that Young Thug's lawyers were doing. They would get it out on cross-examination and shit that Thug wouldn't be on his Instagram or be posting or controlling anything. It was like managed by other people or whatever. This could prejudice K-Flock considering that celebrity fan accounts are well-established phenomenon. So much so that Instagram set forth a number of policies meant to ensure that members of the public can identify genuine celebrity accounts from imposters. Mr. Perez's current Instagram account bears a blue check. An Instagram search for the handles k.flocka and k.flocka with 2 A's asserted by the government to be controlled by my client results in the listing of several accounts, one of which bears the blue check symbol and other which do not obviously represent that they are controlled by in fact Mr. Perez. Oh, so they're trying to say this isn't even his Instagram account in general. Insufficient factual basis to establish the rap exhibits are what they claim they are. The jury should not be put in the position of divining a defendant's guilt in whole or in part from a musical exposition without a tenuous relationship to the criminal conduct alleged. Courts should be wary of overly permissive rules allowing the use of rap lyrics and videos against criminal defendants at trial because themes of violence and criminality have become become so prevalent with the genre that they have little, if any, probative value. The government argues that rap exhibits are relevant because the testimony at trial will show that Mr. Perez recruited participants in criminal schemes through Instagram. However, none of the relevant exhibits or any evidence shown now before the court demonstrate the defendant was involved in soliciting criminal conduct online. So his lawyers are just saying this is all cap. Obviously, they're not going to give in, but I wonder what the judge is going to do here. He's probably going to let this shit in. One of the selfie videos on authenticated Instagram account on June 15, 2021, less than 2 months after he turned 18. What is not present is a factual nexus to any crime charge. Non-specific animosity for River Park Tower should not be admitted to prove that defendant acted in accordance with that trait. The entirety of the clip does not reference Southside DOA, alleged criminal enterprise. The video references OYZ street gang. It must be noted that at pre-trial conference, the government conceded regarding alleged victim Hernandez, we don't think he was actually a member. The fact that OYZ bear no connection to any crime charge in the statement is not in dispute. The government's position is that whether in fact the victim was OY member is irrelevant because the evidence at trial will show that Mr. Perez went to an OYZ area for the purpose of shooting an OYZ member, essentially shot Mr. Hernandez by mistake, but the government cannot elicit testimony of Perez's inner thoughts and intentions without him testifying, which is not anticipated at this time. So I think Ashanti Washington is K-Flock's sister, I'm guessing, was president at defense time. Government would have this court believe that Hernandez's possession of firearm does not tend to corroborate any part of the eyewitness account of what happened, but it is not the case. Miss Washington explained that just felt like he was going to try to shoot us, and that he did reach for something in his pockets. She also expressed her belief that if the defendant did not act to protect them, they both would have been shot. That is clear evidence that she had subjective and objectively reasonable belief that Hernandez had a weapon and intended to use it. The fact that a fully loaded handgun with a bullet in the chamber fell from the coat he was reaching into just minutes after he was shot corroborates Miss Washington's testimony, insofar as it bolsters the objective reasonableness of her subjective belief that Hernandez was armed. Straight up, the government trying to hide that as shady from the jury. Like, that's kind of crazy. Showing them surveillance videos of the guy having his hands in his fucking coat, but not telling them there's a gun in there. And I know it's because of the New York law that I read earlier. The defendant didn't necessarily know there was a gun in there. I guess he couldn't see it yet because it was still in his coat pockets, but he was grabbing it. It seems like he was grabbing it at least. Defense says New York penal law permits the use of force upon another when and to the extent he reasonably believes such to be necessary to defend himself or a third person from what he reasonably believes to be use or imminent use of unlawful physical force by such other person. This is a case in which Perez is invoking his right to defend himself to rebut the allegation that he used force without justification. Hernandez made verbal representation that he both possessed a weapon and intended to use it. Defense rejects completely the government's characterization of the topics Nicholas Zingas, the A&R, which testified at trial. Zingas is being offered to provide evidence regarding his personal knowledge of Southside DOA's business activities. The government simply cannot have it both ways. It cannot be the case that the rap music of Mr. Perez and others can be used to suggest Southside DOA was a criminal enterprise, but individuals who did legitimate business with Finn and his group are precluded from testifying to those facts. That's actually a great point. If the government wants to bring the music side into it, the defense should get a chance to show the legitimate business side of it, right? I actually understand that point. Yeah. Mr. Zingas' experience of Kevin Perez donning the persona of K-Flock and the studio character evidence under Federal Rule of Evidence 4A, which would allow the omission of 404B material. This potential testimony would be limited to observations of Mr. Perez in his capacity as an artist who sold millions of records and generated millions of dollars legally. All right, shout out Inner City Press on Twitter. This guy's been in the courtroom and everything, so go give him a follow and support him. Opening statements. Government, this defendant shot and killed Oscar Hernandez. You will hear the song OYK, OY Killer. Government says you will hear from the defense's own music videos and witnesses, including one who also killed a rival. So someone's going to testify admitting that they killed a rival gang member? Is that what that means? Defense, yes, you will hear rap lyrics. Who's on trial here? Rap music? Question mark. The Bronx is rough. Being a rapper is not a crime. K-Flock is not on trial. Defense, does Kevin Perez have a right to defend himself? Yes. He grew up on Kelly Street and moved to 187th Street, Sevside, Little Italy. It is tree lined. Objection. Judge overruled. Defense, his earliest memories. Judge sustained. So it sounds like the government didn't want them to get into where exactly Sevside is located, maybe because it's near a certain location. Defense, just playing music can bring law enforcement there. He was influenced by Joe Rap. DOA is a music collective, dollars over everything. Instagram was his ticket out of Sevside. The killing in Harlem, he turned himself in. Hernandez followed my client. What his lawyer's trying to do there is point out that the victim walked outside of the barbershop and walked towards K-Flock, and K-Flock kept walking away. And then there was some sort of verbal altercation you can tell on video. So he's trying to switch the narrative here, and also trying to switch the fact that DOA or Sevside is a music collective and not a gang, just like YSL lawyers were trying to do. When the feds come after you, they got your ass. So it's gonna be very hard, man. Defense, he's also
Young Thug had the feds on his ass for 10, 11 years. That's not true. Young Thug could have walked away a free man if he really wanted to. You know what I'm saying? I mean, not if he ain't know, but y'all know what I'm trying to say.
Charged with a violent incident on November 10th, 2021. There was no warrant at that time. They have a confidential informant, and so a federal indictment in 2023. RICO is a complex law, so someone snitched on them, apparently, in terms of that drive-by shooting a month before the murder at the River Park Towers, I think it's called. Defense. No OI was a victim in the evidence in this case. Walking through a park is not a crime. Op can mean several things. Follow your oath. Be fair. Thank you. First witness is NYP Detective Eric Kim, 30th Precinct, heard gunshots. Jury shown 151st Street video. Hernandez dead on the sidewalk. A man yelling, "They just killed my boy." Jesus, that's sad. Defense, are you aware my client turned himself in? Detective Kim, not aware. That's it for Detective Kim. That's why it's such a bummer this isn't streamed, because I would want to see the full cross-examination of this detective. But next witness is Gerald Soto under subpoena wearing a turquoise cap. My brother Oscar got shot. I was with him. Oh man. Family member of the victim. Where were you? I was in the barbershop. My brother walked out and said, "Who are you?" Government says, did he threaten anyone? No, but he got shot. Third witness, NYPD Detective Rachel Crawford of Crime Scene Unit. Photos
How
of
can you hear if he threatened somebody inside though? How can you hear if he threatened somebody if you inside the barbershop? Make it make sense. Dramatic effect. How can you hear if he threatened somebody if he inside the barbershop? Come on now.
the blood on the sidewalk. And here we go. Here's the snitch right here. Cooperating witness Vance Brockington on the stand. OYK video on the screen. Are those guns real? Brockington, yes, and I know. I got guns. Government, did other members of Testified go to others' territory? Defense, objection. Judge overruled. Brockington, yes. What is 4646 Park Avenue? Brockington, we all chill and smoke. On the stand has been cooperator in yellow prison jumpsuit, slumping over behind a computer monitor in front of him. He dropped an F-bomb and the prosecutors looked again. He blamed K for stirring up beefs. I really wish federal court cases were live streamed, bro. The prosecutor did not look happy about him swearing. Witness said, f***ing them and smoking them. Prosecutors winced, then asked, what does smoking mean? Shooting, killing, f***ing them. What?
That's crazy.
He also talked about hand signs. Oh, he identified Sevside DOA gang signs, I would imagine. I don't have much information about who this Vance Brockington is, but I found out his name is Dougie, not to be confused with Dougie B, who is K-Flock's friend, I believe, so don't get that confused. It's not him, but this snitch, how he got arrested is fucking crazy. And I'm gonna read it real quick. Vance Brockington, aka Dougie, and Robert Meredith, aka Red. Since in or about July 2022, the NYPD has been investigating individuals selling crack cocaine in a certain neighborhood in the Bronx. Undercover NYPD officers UC1 and UC2.
Free KK. Free K-Flock.
These guys got caught by undercover cops, bro, selling crack cocaine. July 14, 2022, USC 1 arranged to meet with Vance Brockington, aka Dougie, in order to purchase 60 grams of crack cocaine.
God
The UCs
damn.
met Brockington in the vicinity of 2357 Washington Avenue. Both UC1 and UC2 had undercover audio and
Y'all
video
niggas move
recording
that dope.
devices. Not just a wire, they had video of this shit. After they met him, he said his boy, individual known as Red, would be there in 10 minutes with the crack cocaine. Brockington told the undercover cops and some that Red sold firearms. They told Brockington they would buy a firearm. A few minutes later, UC saw Brockington make the telephone call. Red arrived at location 1. In the lobby of the building, near staircase, Meredith handed UC1 a black Taurus USA firearm with serial number blah 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 and a clear plastic bag containing a substance that appeared to be crack cocaine. Undercover cop handed Brockington $900 for the firearm and $2,200 for the crack cocaine. Brockington counted the money, then handed a portion to Meredith. And then here's a picture of the gun and drugs. I might have to blur that, sorry. Just a fucking pistol and a bag of fucking crack, dude. So that's how this guy got caught. And now he's snitching on K-Flock. I guess he knew K-Flock at some point and knew the gang or something. Maybe he was a member of the gang, I don't know. You guys will have to let me know if this guy's a member of Sevside. But that's pretty much it for day one. I'm very bummed it's not being
Is he a member of oh no, who is this nigga? He might get that murder charge drop, but he getting a murder charge drop. Who is this nigga Brockington? Who is this nigga Brockington, chat? Who is this nigga Brockington, chat? He's not cooked. I hate hating that niggas. Acting like we'll keep him in there. Who is Brockington, bro? Who is Brockington? Who the fuck is Brockington? Nah, YouTube, make sure y'all like, comment, subscribe. If y'all not on the Twitch, make sure y'all come to the Twitch. And I'm out. You need